We will. are you?
All rise. Superior Court of Cobb County is now in session. Honorable Mary E. Staley presiding. Please be seated and turn our cell phones off.
Thank you, Mr. Russell. Take the three that's printed in place. I believe we're ready to proceed. Motions scheduled for the morning are in the matter of the state of Georgia versus Justin Moss Harris. General bill of indictment 149324. Everyone is here. The defendant is present. I believe we're ready to go forward with the scheduled motions for today. Is that correct, Ms. Stagg?
Yes, Your Honor.
Is that a correct statement for the defense?
Yes, ma'am.
Thank you, Mr. Hope. The first matters I have before the court are Rule 22s. I have a Rule 22 from the Associated Press, WGCL-TV, which is CBS Atlanta News Affiliate, WXIA, Marietta Daily Journal. Fox. WHEA and WSBTV. What says the state?
We have no position, Judge.
What says the defense?
We're going to object, Judge, and we're going to continue. Actually, we're going to renew our motion for closure of the program.
Well, I previously denied that motion, and considering required argument, nothing has been added or changed, and I'll stand by the former ruling of the court and deny that motion.
Non-domestic, Freeman versus Walker. The Freeman versus Walker.
Are we in the court? Do you need to get that, sir? You want me to call for it? I need to call on an unrelated matter because I have other calendars going contemporaneously. Is the Freeman versus Mathis case in court?
Walker.
Waller, Freeman versus Waller. Okay, let's do that. All right, I'm ready to proceed.
Judge, we're going to ask you, direct the sheriff, to allow Mr. Harrison to have his hands to use the notes.
We can do what we did previously. I think we had one on.
Right hand, Your Honor?
I think,
Right hand?
I don't know. I think Mr. Harris will know better than us. Signs today, the 11th, the 12th.
matters, Judge. We filed a discovery motion asking for a number of items. One of the items that we asked for was an exact copy of digital devices that were seized, exact digital copies of all data. We have not yet received that. I've spoken with the state this week, and my understanding is that is in the process of being prepared. I bring it to the court's attention only so that if we don't get it, that I've made the court aware that that's an issue, that I expect that Mr. Bourne will get that to us this week, Judge.
That's correct, Judge. We will be getting that to them this week. You've got one of them already burned. They're making copies of the other ones as well.
Very good. Well, if there's a problem, I know you'll call it to my attention.
Yes, ma'am. Other preliminary matters, Judge, you did issue a written order on motions 9 through 14. These were the constitutional challenges to counts 6, 7, and 8. We have filed this morning a written request for a certificate of immediate review. We are asking that those motions, the order denying those motions, that you allow those to be taken up immediately for review by the Supreme Court. Of course, it's discretionary, but we would be asking for that. Let me also, in the same measure, Judge, our motion 7 was an Eighth Amendment challenge to count number 3. From the bench, you orally declined to rule on that, finding that it was not right. There's no written order yet. We filed this morning a written motion for you to reconsider that and allow us to proceed with that motion in the event that the court declines. We are also asking that you allow us to take that up as well on interlocutory review. I think those are the only preliminary matters that I needed to get with the court.
Thank you, Ms. Codmore. I'd like to take care of both of those before we get into the other scheduled matters. What is your argument regarding the certificate of immediate review? And why don't you also address the ruling that I made that prior motion was not right? Well, actually, I don't think you need to argue that particularly, but you do need to argue the certificate of immediate review, your position on that.
Sure.
And then the state needs to respond to the other two, and then you'll have last say and I'll make rulings.
Sure. Judge, Mr. Rodriguez handled motions 9 through 14.
He did.
So I'm going to let him address that with the court.
Yes, Mr. Rodriguez, please.
Can I remain at council table, Judge?
You may, sir.
Okay. I have a courtesy copy for Your Honor, a written request for certificate of immediate review, but essentially, Judge, the court acknowledged in its order that the Georgia Supreme Court has not addressed a right of privacy argument, that the age of consent differs from the definition of a minor in the challenged statutes. While I don't 100% agree that our argument is that specific reason is why those statutes are unconstitutional, the court did acknowledge that the Georgia Supreme Court had not addressed the general idea of our assertion that those statutes are unconstitutional and violate the right of privacy. Recently, just last week, the Georgia Supreme Court decided Harrell versus the state. The Supreme Court number is S15A1045. Again, it was decided last week. That's where 2 counts of an indictment were unconstitutional as applied to the defendant, and that they violated his right to free speech. The court specifically pointed out that the indictment in that case, which also addressed a motion to sever, those counts in the indictment were not properly presented to the jury because they in fact violated his right to free speech. So my position is that that is something that all parties would be interested in resolving before a lengthy trial. Going ahead and letting the Georgia Supreme Court address these constitutional arguments, which I would submit are a matter of first impression in Georgia.
Thank you. Response.
Your Honor, we believe that regarding motions 9 through 14, the law is clear as far as both arguments and both avenues for which the defendant sought to declare these unconstitutional. I don't believe they even made the case for having the statutes as applied even be considered in this case. So, Your Honor, I would ask you to deny their motion. I believe the law is clear in this matter, and this would only seek to delay proceedings in this case.
Anything further to be said?
Ma'am.
I want you both to submit orders. I'm going to take a little bit of time to review that and make a decision. Then I'll make a decision before the next time we get together. I'll go ahead and assign those. Right, now, let's talk about, all right, I don't have a problem with a written order concerning my ruling previously that the motion wasn't right. So, Mr. Gordon, you need to send me an order on that, a proposed order, copy the defense so they can have any comment they may have on the order.
Yes, Your Honor.
What is the argument for the certificate on that?
Judge, in looking at the case that was the state cited previously, it's clear there were some excerpting of those opinions, trying to give the court some superficial support for their position. When we look at those, you see none of those cases actually address the procedural posture in which we're in. In fact, there is a pretrial challenge to the constitutionality of the sentencing part of the statute under count 3 for which Mr. Harris is being prosecuted. What we see is when we look at those cases and look at the actual context, we see the well-settled rule that's mentioned, in at least one of the cases cited by the state, that the law is clear that a constitutional attack on a statute under which a criminal defendant is prosecuted must be made at the first opportunity, and it is too late to raise such question after a guilty verdict has been returned by the jury. That's what the state is suggesting we need to do, is wait and see if a verdict is returned, first of all. It goes on to state Supreme Court. The rationale for that rule is that a party cannot, during the trial, ignore what he thinks to be an injustice, take his chance on a favorable verdict, and complain later. Excuse me, in our motion to reconsider, which we filed this morning, there's a litany of cases, both Supreme Court and Court of Appeals, which set out that well-settled principle of law. There's also, in our motion, 2 specific cases where a cruel and unusual punishment challenge was made, one being as to the death by electrocution penalty statute, and one being the failure to register as a sex offender statute. Obviously, one involved the death penalty and one involved a mandatory life sentence, similar to what we had here. Pre-trial challenges, one of which ultimately was successful as to the death penalty, second also was successful in turning down and finding unconstitutional the life sentence provision of the failure to register as a sex offender. And the last thing I just want to make very clear to the court, by not allowing us to address this, the court puts the state and the defendant in a very unusual position, and frankly, the court's in an unusual position. If this case goes to trial and Mr. Harris is found guilty of only count 3 as regards to murder counts, if in fact the court finds and follows the law, which seems to be pretty clear cut, that that's a cruel and unusual punishment as the law as it now stands, then the court will be left with a conviction in which it cannot impose a sentence. Finally, the fact of the matter for the certificate of immediate review is there's no case that I can find that clearly sets out this issue as to how the court should rule, other than the 2 cases we see where in fact challenges were made pre-trial, one of which it was granted, ruled on prior to trial, and ultimately upheld by the Supreme Court. The second of which was not appealed previously, but it was a pre-trial challenge, and then it was ultimately found to be unconstitutional. So to allow the case to go forward without an immediate review of that issue puts the court in a very unusual, precarious position. I think potentially could cause reversible error in allowing that count to be included with the other counts. But for that reason, we'd ask the court at least let us get the chance to finally have a case that puts this issue squarely on its face, and let the court give us some guidance before it becomes too late.
Argument?
Judge, nothing really different apart from the previous argument. I would point out that in the defendant's motion, I'm just reading through it right now, the state says the state failed to advise the court of Wood's clear statement contrary to its position, where it says the law is clear that a constitutional attack on a statute under which a criminal defendant is, quote, prosecuted. This is a statute based on sentencing. That is the difference, and it's a sentencing statute that we're looking at. So, Your Honor, based on that, I would just ask you to uphold your prior ruling, and also to deny a certificate on the case as well.
Anything further?
Just to make very clear, there's not a case which addresses this issue that's been cited by the state to support its position. We'd ask the court to give us an opportunity to get a case that addresses this specific procedural issue.
I'm going to deny the motion for certificate of immediate review. It's not right, and that would be, that's the only ruling of the court. And I would only give you a certificate as to the issue of whether it's right or not. And I don't see the utility of that, so I'm not going to do that. All right.
Will the court be bringing a written ruling as to the fair to find it to be right, just so that's clear for the record?
Yes, I would.
Thank you, Your
And
Honor.
I've asked Mr. Goring to submit me one, copy you all for review and input if you wish to have it before I sign off on anything. Gentlemen, thank you all. I think we're ready then to begin with the motions that are set for this morning.
Judge, the next thing we've got then is defendant's amended motion 8, supplemental amended motion to quash indictment, special review to count 6. So we're ready on that.
All right. You can proceed.
Okay, we'll call Phil Stoddard.
You solemnly swear affirm the testimony you shall give to the court on this nothing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please, please.
Good morning,
Good morning, sir. How are you?
So everybody in here knows who you are, but for the record, if you would please identify yourself again.
Yeah, it is Detective Phil Stoddard, Stoddard.
All right, and Detective, you are the lead case agent on this particular case, correct?
I am, sir.
All right, so what we're talking about today is are these counts involving, I'm going to refer to the individual as CD.
Okay.
Okay, you know who I'm talking about?
I do, sir.
All right, and that would be the individual who is identified as a person under the age of 18 and count 6, 7, and 8, right?
Yes, sir.
Okay. You did not take a warrant for any offenses involving that individual, correct?
Correct.
Okay. But you did, however, learn of Mr. Harris having some contact with this individual via his cell phone, right?
That is correct.
And you knew that pretty early on, within a day or so of his arrest, right?
I would say yes.
Okay. And subsequently, you have had a chance to review all the communications between the two of those individuals, which were done electronically, right?
Yes, sir.
Okay. And what app or what method would those communications occur?
All those communications were on KIK, K-I-K.
Okay. All right, and in accessing that information on that app, that KIK app, do you have a mechanism in which to extract that information from Mr. Harris's cell phone?
Yes, sir. That was done by our high-tech crimes unit.
Okay. And you've had a chance to review that?
I have.
All right. So you would agree then that I guess the basis of the information you have as to those counts that we're talking about in 6, 7, 8, you would agree those came Those came from information obtained from the extraction of Mr. Harris's cell phone.
Yes, sir.
All right. And with that extraction, it gives pretty specific information as to date and time of any communications between the parties, right?
Yes, sir.
All right, so in other words, if Mr. Harris requested an image through this application on Kick, you would be able to tell the exact date that he asked for it and even the exact time that he asked for it.
Yes, sir, as saved on the phone.
Okay? And would you agree that that's the highest and best information that you've got regarding the timing of any communications?
Yes, sir.
Okay. Now, in particular, looking at, and I know you didn't draw the indictment, but looking at the sort of the dates alleged in count 6, 7, and 8, there's a range. So we're going to talk about count 6. There's a range there that says between March 1 of 2014 and the 18th day of June 2014, correct?
I don't have the indictment in front of me, sir.
Okay. Judge, can I have leave to come over here?
Yes, you may.
I'm showing you.
Thank you.
We'll have to go back.
Yes, sir. You're saying, but we're going to start with count 6?
Yeah.
Yeah, first day of March 2014 and 18th day of June 2014.
Okay, thanks. And in looking at the extraction, you were able to determine that there was communication between CD and Mr. Harris during those particular dates, right?
Yes, sir.
Okay. But you would agree that, and those dates cover the entire month of March, which was 31 days, the entire month of April, which was 30 days, the entire month of May, which was 31 days, and then half the month of June, which was 18 days, correct?
That is correct.
All right, and in reviewing the data from the extraction, you would agree that there were lots of those days during March, April, May, and June, where there was no communication at all between the parties.
That is correct.
Do you, by any chance, do you have those particular dates and numbers? Do you know the dates there were no communication?
I have the conversation in front of me, sir. I have not sat down and
Okay.
gone through it individually.
I know it's going to be hard to go through it in that format, so let me just ask it this way. Would you disagree that during the month of March, there were 16 days where there was no communication at all?
If you want me to take the time, sir, I'll be more than happy to count them right now. I will agree that there were several days they did not communicate. I don't know the number. And without actually counting it,
Okay.
I'd just be going by your word.
Okay, well, why don't we do this? I'm just going to call the days out, and you can just flip through those.
Okay.
All right, we're going to start with March the 1st, George.
I'm not.
All right.
I am close. I'm not ready. Okay, sir.
All right, so I'm showing that there were no communications between the parties on March 1, March 2, March 3, and March 4.
Correct.
Okay. Showing there were no communications between the parties on March 10, March 12, March 14. Am I getting ahead of you?
You are good, sir.
March 16, March 17, March 19, 6, March 28, March 29, March 30, March 31. Did I miss any days?
I don't believe so.
Okay. So if we add those up, would you agree then that there appears to be at least 16 days that there was no communication at all between the parties in the month of March?
I would agree, yes, that there was no communication on kick between those parties.
Okay? And as testified, kick is what we're talking about.
Yes, we are talking about kick. They have communicated on other apps though, but from our records, there's no communication on kick.
Okay. And the information you had was that communication on other apps occurred previously, or earlier, rather, on earlier dates, correct?
I have nothing to show me. I know they communicated on Snapchat. They snapped back and forth, but I have nothing to show me without actually going through it again that they actually snapped during that month. But I'll agree that there's no communication on kick on those days.
Okay. And as to count 6, and I know you don't have the indictment, so I'll show it to you if you need it. There is an allegation that Mr. Harris requested that CD provide a photograph in visual medium involving lewd exhibition of her genitals and pubic area, right?
Correct.
And you would agree, if we take those 16 days out of March that they didn't communicate at all, there's also lots of days during the month of March where no such request was made by Mr. Harris for a photograph of genitals or pubic area. Would you agree with that?
I would agree, yes, that there were days that they talked and he did not request any photographs of her genitalia.
You agree that female breasts are not genitalia, correct?
I agree.
Okay. If that's the case, in the month of March, is there more than one possible day in the entire month of March where such a request was made?
I have one. I have one written down, sir.
Okay. All right, so in the month of March, you can narrow that down to what day?
The 7th of March, 2014.
Okay, so March, we can narrow it down to one day. All right. All right, let's do the same thing then for the month of April, okay?
Yes, sir.
I'm showing there are no communications on April the 3rd. Okay, April the 3rd, April the 4th, April the 5th, April the 7th, April the 8th, April the 9th, April the 12th. Getting ahead of me.
Go ahead, please.
I'm sorry, 12 was the last day.
Yes, sir.
Okay, April 13, April. 14. April 17. April 19. April 24.
There's communication on the 19th.
I'm sorry, on the 19th?
Yes, sir.
Okay. All right. And Detective Stoddard, was that via the KIC app?
It is, sir.
Okay.
Which, are you looking at the updated?
Well, let me see what you've got.
Yes, sir.
Because I may be looking at something different. You had a subsequent extraction, right?
It wasn't a subsequent extraction. It's still the same extraction that was performed on the 19th of June. I believe it was the 19th of June. What it's done is that they went back with a newer or updated version of UFED, or the reader, the program that actually takes that data and reads it. And there are texts and stuff that we didn't see before that this reader is finding.
Well, your printout is a lot prettier than mine. Can I get a copy of yours?
You may. You want it right now?
If you've got one, that'd be great.
I do not have a copy for you. We can have a copy made. This is just, all this is just a copy from that new disc that I believe you received last week
All right.
or the week before. It's the
Your
most
prints out
recent.
very nicely. If I get a copy of your printout, that'd be terrific.
Yes, sir.
All right, so the 19th, there's some sort of contact. All right. The 24th. The 26th.
There's conversation on the 26th.
Okay. The 28th, the 29th, and the 30th. Do you agree with that, Detective Stoddard?
I do, sir.
Okay, so if we've done our math correctly, would you agree there appears to be 14 days during the month of April where there was no communication via CAC?
Yes, sir.
And again, just like in the month of March, a lot of the days where there were communication, there certainly weren't any requests for images of genitalia, right?
No, I have none documented.
And when you say you have none documented, that's because, by reviewing this extraction, there were no such requests during the month of April 2014.
Yes, nothing on kick.
All right, you don't have evidence of a request on any other medium during the month of April 2014 either?
I do not.
All right. All right, so let's take a look at May.
Okay.
Ready?
Yes, sir.
All right, so I'm showing there was no contact on May the 3rd, the 6th, 7th, the 8th,
Well, I'm sorry. Go ahead, sir. I'm sorry.
the 9th, the 10th, the 11th, the 12th, the 15th, the 18th, the 19th, the 22nd, the 23rd, the 25th, 26th, 27th, and May the 31st. Would you agree with those days?
I'm sorry, no, I'm just looking for this long conversation.
Okay.
Yes, sir.
All right. So if we add all those dates up, if I've done my math right, would you agree that we've got 19 days during the month of May where there was no communication between the parties?
You said 19?
Yes, sir.
I must have missed a few. I put down 14, but
Okay.
I'm sorry.
All right. You would agree that it certainly was at least half the month?
I would agree, yes, sir.
Okay. Mhm. All right, in the month of May, you would agree that on the days that there was some sort of communication, most of those days, you would agree certainly don't have anything to do with requesting an image of genitalia,
Correct. Excuse me.
all right? Would it be your position that there were, what, two or 3 days were possibly here in the month of May, where that could be the case?
Yes, sir.
What days are you suggesting?
I'm showing the 5th.
Okay,
There was a communication,
all right.
and we'll stay with the 5th. Yeah, the 29th is just other, yeah, we'll stay with the 5th, sir.
Okay. All right, so let's move to the month of June then. And I'm showing that days where there was no communication between the parties would be June 1, 3, 4, 5, 6, 8, 9.
No, there's conversation on the 9th.
Let's see. Yeah, June 9.
There's conversation.
Yeah. All right, and then the 16th.
Yes, sir.
Okay. All right, so the 18 days in June, it looks like at least 7 days there was no communication at all.
I would agree with that.
And then some of the communication we're talking about, some of these days it really is one word, right?
Yes, sir.
All right. And again, on this, on the month of June, as far as anything that the state is suggesting was a request that CD provide a photograph visual medium involving lewd exhibition of genitalia. Most of the days, there's no contact, there's certainly nothing like that that could be suggested, right?
I would say some of the days there is no context like that.
Okay. So what days during the month of June are you suggesting that there was that specific request as outlined in count 6?
Would have been the day of the death, 6/18/2014.
Okay? That would be the only day?
That's the only day I have.
June?
Yes, sir, that's the only day I have marked down.
Okay. All right, so by your count, what we're looking at is, you said that you think there was such a request suggested on March the 7th, and May the 5th, and June the 18th.
The 7th, the 5th, and the 18th of June.
Okay, I think that's all the questions I have.
Thank you, Your Honor. Take a stop. We got you on cross now.
Good morning, sir.
Questions? All right, Detective Stoddard, first of all, in any of these chats or messages on Kick or any other information you've gotten from the victim CD or from any other forensic evidence, did the defendant ever say the word specifically, please send me a photograph of your vagina?
No.
So in the entirety of this charging document, as it's been charged as an indictment, is it necessary to put the context of the entirety of all of these conversations, not just the days where he mentioned a photograph of the vagina, but others, is it necessary to put these in context to show his intent?
I'm going to object. I think that calls for a legal conclusion, Judge.
I think as a detective in charging this case, having the defendant and why it is charged this way, I think he can have an opinion about it. He testified at the grand jury as to the dates as well.
Which is exactly why I specifically asked him, you did not take a warrant on this. He did not. This came out of the grand jury, Judge. You did not charge these offenses.
Well, we're not in front of the jury, and I'll allow whatever objection. It certainly is not going to stand for a legal opinion.
Yes, Your Honor. So you can answer.
Okay.
Is it necessary, knowing everything you know about the case and having these dates and then the specific language used on these requests, is it necessary to have all of this to put it in context to prove the defendant's intent?
Yes.
And we talked about the fact that he never specifically ever used those words.
He did not.
Okay. First, let's go back to how CD and the defendant met. What application or app did they use to meet?
They first started off on Whisper. CD sent a Whisper out. He responded to it. Then they switched over to Kick.
Okay, I keep forgetting that I can actually ask you leading questions to speed this up a bit. CD was actually 16 years old when they first met back in the summer to fall of 2013, correct?
Yes, CD said that they met online. It was August or September 2013. She would have been 16 at the time.
And she was in high school and the defendant knew her age, correct?
That is correct.
Okay, did he give her his correct age to start with?
No.
With the computer forensic evidence that you have, when you ran this new version of Cellbrite against the extraction, did you find conversations going back on Kick between the defendant and CD that you did not originally have?
That is correct.
Okay, let's kind of go back to the starting of that. Did that begin back in December of 2013?
That would be correct.
Okay, and those conversations now going up into where we actually have a back and forth. Starting in December, those conversations that you can actually see, are those one-sided?
Yeah, they are.
And those are actually just statements made by the defense?
That is
or
correct.
defendant? Okay.
That is correct.
And going back as far as December of 2013, did the defendant in fact make an inference that he wanted to see a picture or photograph of CD's vagina?
Yes, sir. Well, yes.
Okay. Now, going with those conversations, does it get her answer or anything like that?
No, not at the beginning.
Okay. So with that, is there anything further from her end to put it into context as far as his intent or attempts to get a photograph back then?
No, sir.
Okay. Going until, let's go back to, go to March, around the 28th of 2014 on KIT. Is there some time right around there, excuse me, February 28th, 2014? Is there a time around there where your forensic evidence is able to, or tools are able to start seeing the back and forth conversation between the two?
Yes, sir.
Okay, and the first date, is there a date in February where the defendant actually at least makes a statement about seeing a photograph of her vagina?
Yes, sir.
Okay, and is that the first one that you can see that she actually responds to?
Yes, sir.
Okay, so that day, the 28th of February, is actually before March 1st, correct?
That is correct.
So March 1st being a date would be more narrow than February 28th, correct?
Yes, sir.
And so we have an idea, just for the record, you're gonna have to use some foul language, or you're gonna have to use some foul language. We need to state exactly what he asked of CD on the 28th of February, 2014.
On February
I'm
20,
going to object because this is outside of what we're even talking about. The indictment is charged beginning March the 1st. What our demurrer is saying is, the statement hasn't narrowed this down as they're required to. We've got specific dates. It's got to be narrowed down to specific dates. He now wants to go into something extraneous, collateral on dates that are outside of what's even in the indictment. It may be relevant to some issue at some point in time, but it's not relevant to the issue that we're hearing right this moment, which is this demurrer.
Judges to show that these dates in the indictment are actually more narrow than we could have charged. We could have made it broader. We're also arguing that this is an attempted crime. It's going to be a jury issue as to whether the substantial steps altogether actually meet it and whether we can prove criminal intent. So it's an ongoing offense. We can't show exactly when we can show, but it's through the context and the entirety of the dates and all the communications leading up to the day of the child murder that this attempt was ongoing. Thus, I believe it's necessary.
You can proceed.
Okay, and just so we're clear, on the 28th of February, 2014, what statement, evinced a desire to see a photograph of CD and her vagina?
yeah, he says, "I want to see your hot, wet pussy."
Now again, if somebody were to argue with you and say, that could have been fantasy in and of itself or things like that, or the defendant really didn't have any intent to actually get that photograph, that standing alone, would you be able to defend that?
This is just calling for his opinion on something. He's a fact witness here, Judge. I mean, we're getting into kind of your decisions. He's a fact witness, not up here to give his opinion.
Judge, he's the detective who actually charges these cases and things of that nature. I think he can give his opinion as to how you charge and how you prove a criminal attempt case.
I think that's a prosecutor's decision,
Okay,
and I think the question was inartful in any event, so
okay.
you can rephrase if you can rephrase.
I'll try, or ask a different question.
I think so.
Okay. Detective, in and of itself, that question, he didn't specifically say, send me a photograph of your vagina, did he?
No.
Okay. Now, during these dates, I know the defense pointed out a lot of dates where there's no conversation, correct?
Correct.
So on all of those other dates, there's conversation between CD and the defendant.
Correct.
Okay, and even though there aren't specific requests for photographs of her vagina, is there very graphic and sexually explicit conversation between the two of them?
Yes, there are.
Okay, and does this discuss her and other juvenile boyfriends?
It does.
Okay, does he actually give advice on what to do with them sexually?
He does.
Does he talk about what he wants to do sexually?
Judge, I'm going to object again. This may be relevant at some point in time on some other motion, but it's not relevant to the demurrer. I mean, state just wants, we got cameras going, so they just want to get everything in they possibly can through this demurrer. But this has nothing to do with the issue that's currently before the court.
Yes, sir.
Judge, I have to prove that this in context shows there was an attempt and a substantial step. I didn't follow the mirror. I didn't ask to have this heard. I'm not here showing off for the cameras. I'm here trying to create a record to show that this is an attempt and an ongoing offense, and that taking this out of context, one comment by the defendant made on one day may not be a substantial step and may not rise to the commission of a crime, but you have to take it in context to show, and that's why it's been indicted that way. I mean, we'll get to it once I get to actually argue, to Your Honor, but that is why I'm asking these questions.
I think that you are allowed to develop this aspect of the case in the way you're doing it, so I overrule the objection.
Thank you, Your Honor. So, Detective, I believe you answered it, just to be clear. The defendant did talk about sexually graphic things that he wanted to do involving CD during these other dates that he spoke with her as well.
Yes, sir.
And just kind of going on that angle that this may have been, if someone should argue that this was some fantasy or something he was just talking. Did he actually try, were there attempts to meet up with CD?
There was conversations about meeting up.
And were there discussions about specific locations, where he might go and things of that nature, where she might go?
That is correct.
Now, are you familiar with the term grooming?
I am.
And just generally, what is grooming?
Judge, I don't know how much farther we could possibly go. This has got absolutely nothing to do with the demurrer. Nothing. The demurrer says they got to narrow the dates in the indictment. And now we're getting into philosophy of view. The detective has testified that he's identified 3 possible dates that relate specifically to count 6, and we're asking about grooming. It's not relevant to the demurrer. This could be something they can develop at some other point in time for some other motion or a trial perhaps, but this doesn't have anything to do with the demurrer.
I'm allowed that objection.
Thank you, Your Honor. What is grooming?
Grooming would be a sexual predator, an abuser, a pedophile would reach out and start a relationship with a victim. They start off as friends. They would, encourage more interaction between the two of them. They would bring sex into it eventually, in the hopes of having sex acts performed or with them.
Now, did you have any evidence that is there ever a chance, did the defendant complete the crime? Did you have any evidence that the defendant completed the crime of possessing child pornography by actually obtaining a photograph of CD's vaginal area? Did his attempts at doing so to get that, did those continue, and was that ongoing from the first day in the indictment, even before that, all the way up to the day of Cooper's death?
Yes, sir.
Okay, so the second date where there was actually reference made to a photograph of CD's vaginal area, that was, I believe, March the 7th, correct?
Yes, sir.
Okay, and in between those times, the 28th and March 7th, was there other conversation like we've already talked about? Conversations talking about sexual things and graphic details as well?
Yes.
Okay. And on March the 7th, that specific statement made by the defendant, did he actually say, please send me a photograph of your vagina?
No, sir.
Okay, please for the record, tell the judge what specifically he stated to her that would show his intent to obtain a photograph of her vaginal area.
And that morning, he types pussy with a question mark and then please, 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 all caps.
And how did CD respond?
As much as I hate to say it, because I really do, maybe we should be done with this. And I honestly can't believe I actually said that.
All right, now on the days in between March 7th and to the next date when there's reference to or arguable reference to a photograph of the CD's vaginal area or vagina, were there conversations back and forth through the course of that time that were graphic in nature, sexually explicit, as we've already talked about?
Yes, sir.
Now going to that next day, I believe it was May the 5th, 2014, correct?
And that's what I have, sir.
Okay. Now, on that day, what was the specific thing that the defendant sent to CD evincing an intent or a possible step as far as getting a photograph of her vagina?
On that day, she actually sends him a picture of, it looks like a kitten in a person's hand.
So she
And,
sends a photograph of a kitten.
yes, sir.
And what was his response to that?
He says, "Aw, when can I see yours?
When can I see yours?
When can I see yours?"
Just so the record is clear, did he ever specifically use the language, please send me a photograph of your vagina on that day?
No, sir.
I'm sorry, what day is that?
Ma'am, that's going to be on 5/5/2014.
Proceed.
Thank you. Now, between that day and June 18th of 2014, again, was there a conversation that we've already talked about, was graphic and sexual in nature between the defendant and CD between
Yes.
those days?
Yes, sir.
Now, finally, on June 18th, 2014, did the defendant actually, was this the final piece of evidence that you recovered showing an intent to obtain a photograph of CD's vaginal area?
Yes, sir.
And what time was that message sent?
Message was sent at 2:10:56, 2:10 p.m.
Now, before this particular statement, had the defendant been talking with her?
Yes.
With CD? And had he gotten her to send a photograph to him of a part of her body?
That is correct.
And what part of her body was that?
Her exposed breast.
And as a follow-up, and after he had obtained that and engaged in these conversations with her, what was the statement that he made that evinced an intent, arguably, to obtain a photograph of her vagina?
When can I see your pussy?
And what was her response?
Never. Nah, IDK. I think I'm going to break up with the guy from last week.
Now, you talked about some other devices, or other, I'm sorry, I'm old. What would Snapchat be called? Is that an app or?
It's another social media site, and it can be an app on your phone.
When you talked with CD, did she confirm that there were conversations going on all this time as well with or on Snapchat?
I don't remember her saying on Snapchat. If we go back to the actual conversations they have on Kick,
Yes.
they reference Snap a lot.
Okay. And Snapchat, is that a tool where you actually send photographs back and forth?
That is correct.
Okay. Was she able to ever give you any detail about dates for which she would have been asked or had anything done via Snapchat or through that application?
No, sir.
And have you attempted to get records from Snapchat?
I have.
And if things were sent via Snapchat, since she couldn't give you dates and things like that, with that application, are you able to get specific dates or times or the pictures that are sent back and forth?
No, Snapchat does not retain them.
So it's possible that there are other things that you can't prove were or were not sent, and you can't prove what day those photographs were sent, correct?
That's correct.
But there is evidence via the chats on Kick that they were sending or communicating via Snapchat as well.
That is correct.
Just a second, Judge, I may be done. That's all I have, Judge.
As far as the demur goes, Judge, just a couple of follow-up questions here. You mentioned, you were asked specifically about evidence from these chats suggesting an attempt to meet in person.
Yes.
In fact, they never met in person, did they?
No, sir, they did not.
Okay. And the fact of the matter is, had they met in person and had sexual intercourse, that would have been legal, wouldn't it?
Yes, sir. Well, legal to the point of adultery, but, which is not being charged a lot in the state, but legally to her age, being at age of consent, correct.
Okay. And during these communications, you would agree that there were many occasions where she specifically initiated sexual communications?
Yes, sir.
Okay. Sometimes days would go by and she would initiate a conversation saying, hey, I want to give you a blowjob, right?
I can't say specifically, but there were several times where she would start a conversation with a sexual statement.
So the suggestion somehow that this was somehow a one-sided event where he's just asking for photographs, that's not at all accurate, is it?
I would not say it was one-sided.
Okay. Because she asked for photographs a lot, isn't that true?
She did ask for photographs.
Okay. And even though on numerous occasions she specifically requested to have some sort of sexual contact with Mr. Harris, never did it?
They never did.
You got the word pedophile in, and you've looked through all of his devices.
Mhm.
He didn't have a collection of child porn or something like of that nature, did he?
There were photos that we believe is child porn on his device.
Okay. And what leads you to believe that?
If we go back to the Whisper app,
You haven't charged him with anything like that.
well, no, he has not been charged, but you asked for evidence. Let's go back to Whisper for a minute. And we'll talk about, and excuse my language, it's under the username Morgan Freeman's Penis. And he has a conversation with a young lady, or believed to be a young lady. And she does send a shot of her exposed vagina. And during the conversation, he asked, she comes out, she's like, can I be honest? And he's like, yes. And she goes, I'm 15. And that's
I
nice.
Get all this in.
No, sir, but
What I'm asking
you asked
is,
if I had evidence, and I'm answering your question, sir.
Wait. You asked, did you finish?
As I was saying, she's like, can I be honest? He's like, yes. She's like, I'm 15. He's like, oh, that's a nice pussy for 15. And she goes, I don't want to say anything because most older guys are like 15 years old. He's like, wow, well, I'm already in, huh? Yes, haha. Show me more. Make me a naughty older guy. And it continues on. And then she sends a picture, she says it's herself, which appears to be a young lady. And he says, cute, yes. And they kind of go on. When do you turn 16? He's like, you'll be Saturday. She says, you'll be legal then. And they kind of go on a little bit, and he says,
Judge, this is not responsive. The question I asked was,
no,
did he have
No, sir.
videos?
No,
The
sir.
question I asked was, did he have videos?
No, that's, you asked about him being a pedophile. And then, did he have any evidence? And he said, yeah. And now he's testifying, and he can finish. Although I do think you need to wrap it up.
yes, ma'am, I'm sorry. Yes,
Well,
ma'am.
No, that was, you don't need to apologize. I just don't know that we need to spend hours on this.
Okay, and then for just a few more, she sends a picture of her from behind. Looks like she's in a mirror. He asked her to bend over. He asked, do you like me being a perv? Make me a huge perv. And then they talk about going over to kick. So, then there's a second one. This young lady puts on here.
Let me ask you this.
Well, just one
You
moment,
don't have
please.
any idea how old these individuals actually are that you're talking about here, do you?
Looking at them, they appear young. I will say that, sir.
Looking at a photograph of their face, they appear young?
Yes.
Okay. The question is, you don't have any idea how old these individuals are.
Oh, not yet.
They could be 19 or 20 for all you know.
Not from the photos,
Okay.
or from the photos that they're portraying themselves to be.
All right. You don't have any evidence that, well, you know what, as far as the demur goes, I'm not going to ask anything else. All right.
Anything else, Judge?
You may stand here.
Thank you, Judge.
Is that the evidence you have?
Is this for the demur goes?
Do they have any evidence for the demur?
No evidence, Judge.
Argument, are you ready?
I don't think this is going to take a few minutes to argue, Judge, but we have to have a bathroom break. And when I say we, I mean my client.
Well, everybody needs to learn not to drink a whole lot of fluids around me. All right, we'll take a 5-minute recess, 10 minutes. 10-minute break.